So, can you see this? Wonderful. Yeah, thank you so much for the kind introduction and also for the invitation to this lesson. Yeah, I jumped in last week and I'm told that there's a wide variety of backgrounds here, and both from an academic viewpoint as well as from a regional viewpoint. So I tried and give a more general introduction into the German asylum system, and then go a bit into also the question of legal status, mostly then also what happens after the asylum system asylum procedure is over, mostly what happens if it turns out that people do not get a protection status. So I thought about just trying and before a short break that we will take, I think in like 45 minutes or so, to talk a bit about the asylum system, then the legal status of tolerated migrants, and then also very briefly talk about what happens if you don't register at all, if you're, as I called this, undocumented migrants. I'm trying to avoid the illegal term because it brands people the wrong way, I think. And then after the break, I thought to maybe have a bit of a more positive outlook for legal reform that is also going on in Germany right now, and maybe talk about some ideas to reform some things that are in the pipeline right now. Also, not everything is very positive there, but at least some positive outlook. And then in the end, we will have a Q&A possibility. I hope the time will allow that. And also, like, ahead of everything, feel free to write in the chat if something is too slow or too quick, and I will try to adjust, or if there's a question that is worth answering in between. Otherwise, we could just collect questions, or you could write down your questions, and then in the end we will try and answer as much as we can. So, starting with the asylum system in Germany, I will not focus too much on the material law, because I think most of you are from Europe, and the legal foundations of the asylum system in Germany comes basically from international European law mostly. It's Article 33 of Geneva Convention, the non-refoulement rule, and from European directives, which you might know from your practice, and in Germany a bit more important also the European regulation, the Dublin regulation. These are the kind of the foundations where the national law is derived from. So I will not go into too much of the national law, which is, if you are from an international background, it might be too detailed. Just to say that from the European level, we have, as you know it from your countries probably, the international protection, which is refugee status and subsidiary protection. And then in addition, and I think this is also the case in many other European countries, that there's in addition a national deportation ban as a legal status that you can get after an asylum procedure, which, if you simplify it, is mostly the standard of Article 3 ECHR, or if you go into the European Charter of Human Rights, it's the same wording basically in Article 4 there, which is also due to the jurisprudence of the European Court of Human Rights, can be a very broad protection basis. So we kind of, I didn't even take into this. We have another thing that I didn't put on the slide here, which is also an asylum status that you can get from the German basic law, from the constitution, which has become so irrelevant that it's not that I didn't put it on here anymore because there was a clause in the 1990s introduced into it that said whenever you come from a safe third country, which is basically every other European country, you cannot claim this protection status. And so if someone basically doesn't fly into Germany directly, you cannot even claim that protection status. It doesn't matter much because the refugee status is virtually the same thing. So the important three material status you can get from an asylum system or in the end of an asylum procedure is the refugee status, the subsidiary protection, and the national deportation ban. This just to the material law. What is more interesting for this forum, I thought, is to go into the procedure quickly or as an overview. And I think also there you might recognize some things that will be very different, very similar in your countries. And then I will highlight in a minute the things that are maybe a bit different from especially countries like Italy and Greece or Spain, which are more often first arrival countries, while in countries like France and Germany, there's a lot of problems that arise from it not being the first country of entry for people. So people arrive here in the beginning, they claim asylum. They can claim asylum in Germany with every state institution, and that state institution is required to forward them to the federal ministry or federal office or administration for asylum seekers. They are registered. You will know that from your country with fingerprints, and this goes into the European database that tracks basically where people register for an asylum application in Europe. Then they are relocated within Germany. There's a certain way that they are relocated in Germany, so it's evenly distributed on the different regions. And then they lodge their formal asylum application there. What happens first, and this is more important probably in Germany than it is in countries of first entry, what happens first is that you are led into the Dublin procedure. And there, oops, I clicked on the wrong button here. And there you get a first interview that tries to determine which country is responsible for your asylum application. This can be a very, I think you already had a lesson on this already. This can be a very complicated system. I always try and stress that it's not at all the case that it's always the country of first entry, which is kind of the picture that is given in the media, that people have to stay where they enter Europe. That's not at all the case. There's tons of ways to work with the Dublin regulation. And also maybe as a side note, I'm sometimes quite happy that they haven't reformed it yet, because I can only see it getting worse at the moment. And right now, having worked a lot with the Dublin regulation in Germany, I can say that it gives you at least some leeway to help people to stay in Germany if they want to. In theory, it is determined whether your asylum application is admissible or inadmissible according to the Dublin regulation. If it's inadmissible, in theory, you are transferred to the member state that is responsible. This is very complex. I will not go into details the way exactly how this happens. But if it is admissible, you get your hearing on the material merits of the asylum claim. Then after the hearing, it takes sometimes a long time. The decision is rendered by the federal administration for asylum seekers. This can be positive or negative. If it's positive, you get a residence status according to your protection status. So if you get if you are recognized as a refugee, you get a different residence status than you get if you get a national protection ban, for example. And if it's negative, you get a leave order, and that leave order basically says that you have most of the time 30 days to leave Germany voluntarily, and if you don't, then you can be deported. You can fight this in court. You can go to court. In this case, in first instance, then again, there can be a negative or positive decision. If it's positive, you can get the residence status. If it's negative, you return to the leave order. And then, which is a bit shorter here, there's another there's different instances in court that you can try and exhaust, but this gets more and more difficult the higher you get, especially, yeah. It might all get into too much detail if I go into the higher levels of court here. Just to give you an overview of how it works in general or in theory, next, I wanted to highlight a few specific procedural issues regarding Germany, because, and I already touched upon this briefly, that this admissibility procedure, basically what happens before your material claims interview, is much more important probably here than in, as I said, countries of first entry, because we get basically three kinds of cases that arrive here and that are often determined as inadmissible. So they don't even look at the material claims. The first one is the Dublin case, which is when the Dublin regulation is applied, someone is in another member state of the European Union in the procedure. So someone started the procedure in Italy. There's no decision yet in Italy, at least no final decision. And while the procedure runs, they go to Germany, and then Germany says, no, we're not responsible because Italy, in this case, is country of first entry. There's no other criterion that allows you to stay in Germany. And then you get the inadmissibility decision, and then you get a transfer order or leave order with the a threat of transfer to Italy in this case. The second very common procedure that or decision of inadmissibility that we get here is if someone already has a protection status in another country. It's quite a different, it has quite different ramifications. If you get one, if you are in the Dublin inadmissibility or the protection status inadmissibility, which might also lead too far right now. That it's also an inadmissibility decision. They don't even look at your material claims for asylum, and they threaten to transfer you again also to the country or to the member state that you got the protection status from. And then the third inadmissibility decision that you can get is if you get a full rejection from another member state. And this is one that might also be very interesting in thinking of how to prepare people before they come, if they say they want to go to Germany in another member state, because you get an inadmissibility decision there, but the leave order and the deportation is not to the other member state, because Germany says, well, you already got one asylum procedure in another European country. We think that they already looked at your material claims. So everything that happened until the moment of that decision, we will not even look at. And if there's no new reasons for you to claim asylum, like that was 5 years ago, and now I had a lot of demonstrations where I was at, and anyway, the situation in Iran also changed. That would be a new reason. If there are no such new reasons, then the deportation order is not back to, let's say, Italy, but it would be back to your home country. So Iran, in my little example before. the thing here, and this is something that also the administration in Germany often does not understand, is that the administration has a very high burden of proof that the procedure is fully rejected, that the claim is fully rejected in the other member state. So if someone gets one rejection in Italy and they bring a lawsuit, or it's even not clear whether they brought a lawsuit or not, and they go to Germany and they get this inadmissibility rejection for being rejected in another member state, if it's not completely clear that if this person went back to Italy, they couldn't take up the asylum procedure again, then it's unlawful to give this third kind of procedure. And this is also something that I would find interesting if people are kind of, yeah, I mean, sometimes when you go to court and fight these decisions, what helps you is that someone said in the interview, I was rejected, but I took a lawyer and I tried to fight this. And then you can point to it and say, well, look, he took a lawyer, and probably this lawyer brought a lawsuit. And where did the administration really clear up whether this lawsuit is over, what's the fate of the lawsuit, and so on. And the administrations can never clear this up, because often Italy doesn't even answer. In Greece also, they say the application was denied, but they never say which instance it was denied, and so on. So it's sometimes good if there's even if you want to leave anyway, if you maybe bring the lawsuit in Italy and leave or so, because then you don't get, if you move on to Germany, you don't get the this very bad rejection where you then are all of a sudden like subject to deportation to your home country, which often is not a very good option for people. Just in general, ways to prepare people for these procedures is also, and people often don't know this when they come, that you have to, especially in the first two cases, talk a lot about what happened to you in Italy or in Greece or in Spain or wherever, why you can't go back to that country. What you read all the time in the interviews is that people say, I wanted to come to Germany all along, and this is where I want to stay. And with that sentence, the procedure is over, because they often don't ask anymore. People think they don't have to say anything anymore. And then they say, well, they didn't tell me why in Italy the conditions were so bad that they couldn't go back to Italy. And often these reasons are there. I mean, people lived on the streets, they couldn't get housing, they couldn't get food or medication or whatever, and you could win these cases. But people just don't know they have to talk about it. They think I'm here to talk about what happened to me in Syria. They think they also, I sometimes think that they think it's a compliment to the countries. I say, I wanted to come to your country all along. But it takes sometimes also in the consultation with people, it takes sometimes half an hour or an hour so that people understand that they really have to talk about the other member state. Just to kind of highlight this, in any case, these things are, you always have to determine them on the individual cases. You can't give any really general recommendations, just so documenting and recounting the circumstances in the other European member state. It's never a bad idea, especially when they are difficult. Maybe not so much if they have been very good or easy, but this is not the case in many instances anyway. I will maybe move on. I could talk a bit about those last two bullet points that I pointed here. Maybe just quickly, crossing the border to Germany can also be difficult for people. There are these pushback decisions, which are somehow determined legal if they are in a certain procedure, if they catch you in the immediate connection to the border. and then they have these very fast and quick rejection procedures. I think this might be something also in this activist context, we might connect much more on these things, because often we don't even get the cases. People are sent back to Austria often and have been treated very badly, procedurally wrong, but no one fights it because people don't come to Germany, and you would have to fight the German authorities. Just also, I mean, if it's easier if you enter the country and you are really in the country and then lodge your asylum application, because if you do it right at the border, they can say they have a legal construct which is very questionable, but it is there anyway, that they say you didn't even enter the country as long as we are kind of in control of your situation at the border. So that's a difficulty that I wanted to point out in the procedural part of this presentation. After the procedure, this is what was not on the little thing here. It ends with the procedure being over, but it's not at all over for people at that point. After the procedure, well, if you get a protection status, you get a residence permit and everything's fine. That's the good part of the story. If you get a rejection, I already said you get this leave order, you can leave voluntarily 30 days. And if you don't, you're subject to deportation. And if you then don't leave still, you get this German status tolerated, which is I don't know whether it exists in this way in other countries, but here it means basically that you're subject to deportation, but there are some often temporary legal or factual obstacles that are so that the deportation cannot be pursued. Legal obstacles are, for example, if you are pregnant and it's very close, I will go into an example, to the birth of your child, then legally you cannot be deported. It can be an engagement that is very, very close to marriage. So in 2 months or so you get, or 2 weeks, I don't know, you get you would have the right to stay because you would be married. So it would be illegal to deport you right before that. Children can be a reason. I mean, you cannot separate someone from his children. Illness can be a legal reason. Pending procedures also, if they cannot kind of take away, if you have a pending procedure that might work out for you, but you are still subject to deportation, they cannot kind of deport you and create the fact that you're not there anymore, and therefore take away your right that might be decided in that procedure. So those are legal reasons. Factual reasons are often that there's no flight connection. For example, Russia at the moment, there's no flight connection from Germany to Russia. Anyone who is rejected here as a Russian citizen, they wouldn't be deported just because they cannot deport them. No passport is one of the most common ones. Most countries say they only most countries only take their citizens back if you show them the passport, or the administration is just overoccupied and doesn't have the capacity to deport you. That is also a reason, a factual reason. The problem with that status is that once the obstacle is removed, this toleration status can immediately be rescinded and you can be deported. So there's no flight connection to Russia now. If the war, I don't know, ends and Russia, there's again a flight connection to Russia, the next day they can take away your toleration status and deport you to Russia. This creates a lot of uncertainty or insecurity for people. I mentioned the pregnancy example. I will have a look at the time quickly. I think we're good. I mentioned the pregnancy example. For example, you get protection, and this is kind of parallel to labor protection law in Germany. You get protection 6 weeks before the date of birth, which is not much in my opinion, and 8 weeks after the date of birth. it's and this is, yeah, I mean, it's not much, and there's a way to kind of extend that period if you get a doctor's letter that you are a high risk pregnancy, that your pregnancy is high risk. Then most of the time, or there's also jurisprudence that they have to tolerate you earlier, basically the whole pregnancy. So you can see there that in this example that this toleration status can be a very insecure status. That, I mean, if you are pregnant and you have to wait until 6 weeks before giving birth, and it's insecure until then, and then you get a few months, and then again you're subject to deportation. This can be a very, very stressful and certainly also not good for a pregnancy, I think. Another example that is less volatile or less insecure is often what I already said, that there's no passport, and they cannot deport you to a country that doesn't take you back because there's no passport. There are sometimes within Europe, this is different. You can deport people to other European countries without passport. This is due to European regulations. But for example, Nigeria is a country, but they don't take you back. They don't take citizens back if you don't show them the passport. And if there's no passport, then people have it a bit in their own hands whether they can be deported or not. The thing is that the administration has a lot of tools by now to try and make you get your passport from the country. They might take away your work permit. They might cut social security funds, and they also created a very kind of a lower toleration status if you are not working with them to get the passport. This is a whole different. I mean, it's a whole different thing to kind of maneuver this thing, and it leads to very contradictory situations where people try and get their passport, but not try so hard that they would actually get the passport, because that would mean that they could be deported. Yeah, it turns out to be kind of schizophrenic in many cases. Just to give you an idea of a situation that might be less volatile for people. Legal ramifications of the toleration status are, most of all, the residence status is legal. You will not get like a criminal procedure for illegal entry or illegal stay in Germany, because it's a legal status, or a legal registration with the authorities. You can get work permits, especially if you are here for a very long time. A lot of people are tolerated for a very long time. After 4 years, they cannot deny you anymore the work permit, for example. You can register for purposes of social security, healthcare, education. Also for daily life, it's very important. I mean, if it's just your document that you can prove that you are here legally and that you have a status. And also there are some pathways to a secure resident status if you integrate. And I use the word integration a lot with quotation marks because it's a problematic term, but I'm using it in this presentation because it's kind of also a legal term in Germany, which doesn't mean that I don't criticize the term. But, so if you can use kind of the time that you have during this toleration period to learn the language, get education, work, and I will point to this in a minute. And then there are options to kind of there's a term in German which is Aufenthaltsverfestigung, which is kind of put your stay on more solid ground, basically. And in the end, you might get a permanent residence status. Interestingly enough, I kind of framed it in this way: this toleration or a deportation or toleration. There's no in between, because, and this is something that the administration often does not get, they have to either deport you or they have to tolerate you. You cannot kind of leave people in the limbo where they aren't either. Already, so there's of the highest German constitutional court, there are decisions that say it's not, you cannot leave people in this in a situation where it's not clear what their status is, and if it's unclear when they can deport you. So if it's decisions vary, but most of the time they say at least if it's 3 months away, the deportation, until that point they have to tolerate you, because what are you going to do until then? You have to get kind of, if the police asks you what are you doing here, you have to show them something. So it's not a decision of the administration whether they want to tolerate you or not. If they cannot deport you, they tolerate you. It's a legal and factual thing. And this is exactly something that the administration never gets or often doesn't get. They think that kind of, as when they give you the paper, you're tolerated, and if they take the paper away, you're not tolerated anymore. And this is not the case. You're tolerated, and the paper shows that you're tolerated. The paper is not your status. And this kind of this requires a bit of abstraction that and takes away power from the administration, which they don't like to give away. The fight is, and I just had this 2 weeks ago in a very contentious case. The fight is also what does unclear mean? If they can deport you in 6 weeks, and if they say, well, I'm sure it will work out, is that unclear, or is it, or do they have to show in detail that it will work out, or what status do you have until then? There are a lot of fights in these fringe areas. It's much easier for people who, or it's decided already for people who cannot be deported because there's no passport, because the courts said no question, you have to be tolerated in that, and whether you have the paper or not, you're tolerated. It has a lot of ramifications, because many of the applications that you can lodge to secure your stay have the precondition that you are tolerated. And I had this case 2 weeks ago where they tried to deport someone, it failed, and then they put him into detention, and then and he had clear reasons for a permanent residence status. And we tried to apply for that then, and then the administration said, well, but he's not tolerated, we will deport him in one month. And the courts also would have held that decision in this case. We were ready to go to the Constitutional Court, and then they gave in. But basically their reason was, well, he might fulfill all the other criteria. He was here more than 8 years and all that. And we'll go into some of the other reasons in a second. But at the moment, his status is not the state of toleration. Therefore, this law cannot apply to him. Just because they said, I'm sure we can deport him in 6 weeks. And then we said, please show us how you are planning to do this, and how this is not unclear. And the court kind of said, well, you have to show that it's unclear, which is proving a negative, which is impossible. So just to show you what kind of fights we are fighting around the status, and how the status can be very important suddenly if you are in an individual case. Problems of toleration in practice. I touched on some of this, and those 3 example cases, in the end, I put them in a later slide also, because I didn't know how much time we would use up or so. I mean, often with this toleration thing, there is some discretion that is given to the administration, especially when it comes to residency restrictions. So where you have to live in Germany, whether you are allowed to work or not. And we talked about the insecurity that people think at least they can be deported at any moment. And the most difficult thing is that the administration does not always act lawfully, and you cannot, you cannot have a lawyer on every case, and especially with this seeming discretion that they have with the toleration status, which often, due to jurisprudence, they don't have discretion, but the administration doesn't know, the applicant doesn't know, and if you don't have a lawyer involved, they just do whatever they want. I would have 3 cases to show you this, but they make more sense to talk about in the end, because then you will understand more of what I was going to talk about, the pathways into the legal resident or secure residence status. Because this was, I will have a quick look into the chat whether, okay, there's any questions until this point. Okay, we can answer those in the end. Because it was in the title of the presentation, I also included in one slide the undocumented status, which can be very problematic. It's basically the case if you don't register with authorities at all, and then you don't even get a toleration, and you don't have any paper to show. And that would mean that your stay is actually illegal in Germany. There's a law that allows either fine or imprisonment, but I would say imprisonment is too, there always again has to be proportionality, and usually you would get a fine, I'd say. Depends, probably also on the region and the court that you would get to. It's not out of the question that they also have prison sentences that are then kind of put on probation. But your stay is illegal, and if you get a fine, that also it's very bad, because it complicates your whole stay afterwards. If you want to have this putting das Aufenthaltsverfestigung, like it's putting your stay on more solid grounds, then you have a criminal procedure in there. This complicates everything, and it's really not worth it. Also, and that's a huge factual or practical problem, is that whatever administration you go to, they have to report you to the foreigners office, and that bars people from going to seek healthcare, to seek social security, to seek housing. They're not, just because they are not documented doesn't mean they are without rights, but it really bars them from access to those rights. Everyone in Germany, everyone who is in Germany has right to social benefits. But if you know that once I go and claim social benefits, they have to report me to the foreigners office, and then the foreigners office knows about me and they want to deport me, then you will not claim social benefits. What is not included in this reporting thing is hospitals, because there's a doctor-patient confidentiality in there, so they cannot report you. What is also explicitly not included is schools, and obviously also private institutions don't have to report you. So there are some structures in Germany, also some doctors who in some countries, some cities once a week go with a van somewhere and treat people, and there are some structures, but it's a very precarious situation to be in. Also, you just have to imagine what it means for your daily life, and especially if as a person of color, you cannot be ever in a police control, for example, because they would see that you are not registered. And this is, this really infringes on your daily life. Also, another example that's interesting that I read about, I didn't have this in a case yet, is when you are if you work, you're not allowed to work without if you're undocumented. But if you do work, then you are entitled to the wages. It's not like that you cannot claim the wage afterwards. But what are you going to do claim this. Are you going to go to court? Yeah, you can go to court, but once you go to court, you have to give them an address where they can find you. And the court would also have to report you to the authorities, and then they would find you and deport you. So that the employer can always, they have this hanging over you and say, well, I'm not going to pay you any wages because you will not claim it anyway. You can do this through lawyers and so on, but then yeah, how would you have a lawyer if you don't even get the registration? There might also reasons sometimes to do this. I would recommend that you try and find a lawyer if you're in this situation, and try and reappear or re-register, and then with a specialized lawyer, so you can kind of maneuver this illegal stay fine, because you don't want to have this into your in your file. It's not an easy way, but specialized lawyers can help you there. I will go on to what I call pathways to a residence permit, by explaining kind of the general system of residence permits in Germany. They're basically, and this is an old concept, they used to call them tracks. It's like, if we have a humanitarian track and we have a labor migration track. And if you enter Germany on one track, you can imagine that you have to stay on that track. And there, in theory, and I think in former times, it was stricter. You should stay on that track. And if you want to move from the humanitarian, you can always move into the humanitarian track. But if you want to move from the humanitarian track, the asylum protection track, into a labor migration track, which is, I want to come to Germany just because I got a good job offer, then you cannot do it in Germany. You have to exit Germany again and do a visa procedure to re-enter Germany with the right visa on the right track. So that's the theory of this old and overcome concept, and that's what we try and fight and reform also at the moment. There are, but it's still in place to a large degree, and for many people who are in the humanitarian tracks, there are a lot of residence permits that they cannot get. I mean, you might know from your countries the blue card, which is kind of like, yeah, it's a labor migration thing that's European. You cannot get that, and I think it's also European law, so it must be the same in your countries also. You cannot get that if you are in the humanitarian track. And there are, I mean, you cannot apply for a residence permit as a skilled laborer if you're in the humanitarian track, which always means, I have to add that, is that if you are in the humanitarian, if you applied for asylum and either the application is rejected, or you took the application back, or you are still in the procedure, that means you being in the humanitarian track. If you get the status, then it's more open, but then you have a resident status anyway, so it's not so relevant. Also, I mean, you can imagine all these things like au pair, a student visa, and so on. It's very difficult to get into those if you have a rejected asylum claim. There are some ways to get, or those I don't often still consider to be the humanitarian track. There are some ways to get a resident status for people who have rejected asylum claims. And most of them, and you might know these also from your countries, because they also come from often international EU law or constitutional law in our case, but which is similar in many countries. Article 8 ECHR might be one to mention. There are some that just take into account that if someone lived in a country for a very long time and you would deport them, it would be an infringement into Article 8 in this case, ECHR. And also the European Court of Human Rights decided at one point you have to open up it's an infringement into your right to private life if you have no way whatsoever to kind of get your stay on a more solid ground, if you have some security. So this limbo of the toleration cannot be eternal. That's basically what the European Court of Human Rights said, because that would be an infringement on Article 8. So there have to be some pathways to a residence permit. And I listed some here. Also, I mean, they're more complex than I listed them here, but just to give you an idea, we have this residence permit, which is kind of the last thing that you can aim for comprehensive integration at the moment, and they're trying to reform that to make it more easily accessible. At the moment, if you're tolerated and in the asylum procedure, all these times are counted into it, all these periods of time. If you're in there for 8 years, 8 consecutive years, if you have learned the language in that time, if you have partial economic self-sufficiency, if you do this kind of, there's an integration test, and if that's what I mentioned before, if you're tolerated at the moment where you apply for it, then you can get a residence permit. So after 8 years, you kind of have this opportunity to change tracks. 8 years is a long time, and also the authorities get a long time to try and deport you. But I mean, there are many cases where you move into this, and there are also some ways. I mean, if you are living together with a minor in your family, then it's reduced to 6 years. They're now trying to reform it, so it would be 6 and 4 years. So they're trying to make this easier, which is a good thing. But it's still especially a very high bar. There's another comprehensive integration thing. I call this comprehensive. It's a direct translation from my part. I don't know whether there's a better one. For minors, which is minors and young adults between 14 and 21, if they have if they go 4 years successfully to school, whatever that means, and then you can get it after already 4 years. Obviously, family reunification has to be a way to change track or to get permanent residence. I mean, that also comes from European law. If you have children or German children or children who have residence status and stay through that, or if you marry, this is an option for many people. And then they created some pathways, which I might come back to later, which are because Germany has such a big problem with not having enough skilled laborers, they created this apprenticeship toleration, which is a tolerated status for people who have started a state-recognized apprenticeship, and it's a toleration status that cannot be taken away from you. So they cannot also deport you. It's kind of a secure toleration. For that also you have to learn German, because you will not get one of these state recognized apprenticeships without having a certain level of German. And but this is kind of also an aim for many people to secure their stay if they know that the asylum procedure will not work out for them. There's one on work-based, one toleration status, which is very difficult to reach and has very little relevance in Germany. What does this mean for the whole asylum system and for the way to counsel people? This, I think, is an interesting point. So as a responsible lawyer, if someone comes to you and is not, say, from Syria, where it's clear that they get a protection status, then the responsible way to counsel them is to tell them about plan A and plan B. So you explain that plan A is now the asylum procedure. We try and do everything we can there, but you cannot count on this working out. Take someone from Nigeria, for example. There are good claims to asylum from Nigeria also. Often this whole human trafficking thing and so. But the problem is that many courts in Germany don't recognize this, that you never know which judge you will get and so on. People shouldn't feel kind of very, it's too general, but for many people, you have to make clear to them that they shouldn't feel too comfortable in the temporary security that the asylum procedure gives you, because everything might not work out in the end. And therefore, while you have this time that the asylum procedure gives you, you have to work on Plan B. Plan B is language courses, these integration classes, work, education, maybe try and find an apprenticeship. And if you work this way, then it's very, I mean, you have a very good shot at securing your stay in Germany. Obviously, this is more relevant for some than for others. Definitely, I mean, the whole Ukrainian situation is different in the whole of Europe anyway. As I said, for a Syrian, for example, you don't have to stress the Plan B thing so much, but often you get cases. Also, as a lawyer, you get cases in the end when kind of everything went wrong in the asylum procedure, and you saw, well, this person had 2 years now to actually work on the Plan B thing, and no one told them that they had to. Or someone, I just had someone who did it perfectly. Basically, we got the rejection now in the asylum case, and she had a apprenticeship and she can stay through that now. But she also told me that it's coincidence that she worked on this because to get the apprenticeship, because the first lawyer she had didn't tell her about this Plan A, Plan B thing. So this is one very like basic thing that every asylum lawyer in Germany should kind of tell their clients, I think. I have this, I'm coming back to the slide with the toleration, problems with toleration. I'm wondering whether we should take a break or whether we should
we can
on.
start right now, the break, and see you in 10 minutes less.
Yeah.
Okay.
Good. And maybe after, I mean, if you have questions so far,
it's just one question
can...
here. Probably
okay.
It was a question about the pregnancy you talked about. And CV Menes Cadena asked, a high-risk pregnancy is in the first month could be considered as a condition to suspend the deportation process.
So there are no secure general answers on this. In my experience, if you have a doctor, it's not enough to just say I'm a high risk pregnancy. If you have a doctor who writes this into a doctor's letter, and the term has to be in there, either high risk pregnancy, or in German it's Reiseunfähigkeit, which is you are unable to travel. If these terms are in the doctor's letter, I would hazard the guess that they wouldn't deport you. And if the doctor says that in the first month of the pregnancy, it's a medical question, which doesn't mean that I would say in every case this will always work out, because there's so much leeway in these situations. And also, even if it's legally the way that legally it's the way. I mean, if the doctor says it's high risk, it's high risk, and then you shouldn't be deported. But and in all of these cases that I have down here, the legal situation is something different than what the authorities did. So just to take away the confidence a bit, but still, what you should do if you have a pregnant client or so, and it's not, you're not close to the 6 weeks before pregnancy, you should get this doctor's letter and send it immediately to the foreigner's office. And then, I mean, I would really hope that they don't deport you. And if they do, you get a lawyer and fight it in court right away.
Okay, thank you. Let's catch up in 10 minutes.
Yes.
Okay, thank you. I think we can start with the second part.
Okay. I will share the PowerPoint again. Yeah. So I was wondering if there are any questions at that point, I can also go into it. It might be a good moment, or I go on a bit, talk about.
For now, it's no one asked a question in the QA, but probably at the end of the lesson, we can allow them to speak. So if someone,
good.
I mean, actually, I have a question, but I can also do it at the end. I mean, it's not because I wanted to ask something more about the apprenticeship tolerated status, let's say, or permit, and because I didn't understand if, for example, you had to meet specific criteria to get it, aside from having an apprentice contract, something like working contract, something like that, on specific sectors, for example, and if you have to be already recognized as a tolerated migrant, in the sense that you need to have already the toleration status or not, and whether or not there have been changes in the regulation of the status of tolerated migrants after COVID or during COVID. But if you want, you can answer later. I mean, these were some questions.
It's a good question. I think I'm looking at. I have a quick thing on the apprenticeship thing here. Doesn't go. I can go more into detail. It's an interesting thing because it's become kind of an anchor or an option of last resort for many people here. I will just answer the questions right away. I think so. First of all, do you have to be tolerated to get it? Yes, and I would go back to the point. It's not a choice whether you're tolerated or not. You cannot get it if the deportation is immediately or it's really close. I mean, if you apply for it and they say no, we have a flight booked in 1 month and you are on the flight, you're not getting it. But if that's not the case, you're factually tolerated anyway. And that's what I talked about before, this tolerated or not slide. Even though the administrations don't get it, you are tolerated. If they haven't already organized the deportation, it's very close. So yes, you have to be tolerated, but it's not a very high bar. With a few caveats. The thing is, I mean, so I don't know whether everyone knows about this German system of apprenticeship. It's kind of it doesn't exist in every other country. We have this. It's quite a formal institution in education in Germany. If you get this so a state recognized apprenticeship here is that you have this dual education where you are in a how do you call it, like an apprenticeship school, or like in an employment school where you get like two days a week or so you get education on I don't know, accounting, whatever like you need for the job, and 3 days a week you are working already in one of these for an actual employer, and you're also paid money, not much, but you are paid something. And this is a very fixed institution. It has to be at least 2 years, and it's usually 3 years. And so it's not something that you can just that I could just say, well, I'm creating an apprenticeship now and everyone's safe. But you have to be also you have to qualify for these as an employer with your apprenticeship offer for offering that. So that it's not. I mean, you have to find an employer who does that, but that's possible. then usually they only take you, and that's the highest obstacle that for people to overcome. They only take you if you have usually B1 German level or sometimes A2, with the promise of you will get better once the apprenticeship starts and so on. So that's why it's so important to right away start and study German, because if you want to have that as an anchor or as an option of last resort, you really want to have at that point your German level to get the apprenticeship. So any of these apprenticeships qualify. I don't know, there was another question in there.
No, I mean, what I meant at the beginning was if you needed to, if you would need the paper to get these specific status of toleration. So I don't know if I explained myself.
Which paper you mean? Like
the paper of the status, let's say the residence permit connected to this status.
Yeah, I mean, so the way this works is that you, I mean, you get this apprenticeship offer, you sign the contract, and then you go to the foreigner's office and say, here, I want to have the special toleration. Maybe you have another toleration before. I want to have the special toleration for the apprenticeship thing. And then they think, do you have the contract? Yeah, here's the contract, and so on. And then you also another obstacle might be that you have to be allowed to work for the apprenticeship. That sometimes they try and shut it down there, or you have to fight about it. But then you get in your toleration, you get written the paragraph, the number of the law for the apprenticeship toleration, and then you know that you're secure. They cannot just take it away. Okay. And then the way it works then, and we might get into this later, if you go through, you get it for the time of the duration of the apprenticeship, you're tolerated. And if you finish the apprenticeship and the employer takes you on, then you get a real residence permit, and then you're on the track of securing your stay, because if you stay on with that residence permit, and then after 5 years you can apply for the permanent residence, and there you go. If the employer doesn't take you over after the apprenticeship, you get a 6 months period where you can look for another employer in the same field who takes you on. So you're not bound to one employer, but you have to find an employer. And this isn't, I'd say this is not the biggest obstacle right now in Germany, because it's everyone is looking for employees. It's crazy here, especially if you do an apprenticeship in, I mean, if you do something like care work or so, then no, I mean, they will try and employ you right away. Language is the biggest obstacle for people. I'm seeing how long is the first residence permit. So I understand the first residence permit after the apprenticeship thing. I would have to look at it, but from the top of my head, I think it's 1 year. And you have to renew it, but if you stay on with the employer, it will be renewed. But I would have to, I mean, to be very secure, I would have to, very sure I would have to look it up. So that regarding that question, I might kind of throw in now 3 little examples that illustrate mostly the point of access to justice, which I made before, that like just because you have the right on paper, it doesn't mean that you will get it. And those are 3 cases from the last 3 or 4 weeks that I had here. The first one was someone who was in Germany since 2014, comes from Ethiopia. And since he was here since April 2014, he fulfilled the condition of the 8 years that I highlighted before in April this year. And usually the Foreigners Office also has, I mean, in an ideal world, they would, when he goes there, they would say, hey, look, now you qualify for this, why don't you apply for it? They never, or they often don't do that. They see themselves more in the capacity of trying to remove you from Germany. So they didn't do it in this case either, no consultation that he would actually qualify. And he was tolerated on the reason that there was no passport. But he got the passport in summer of 2022. The administration said, well, if you have the passport, we will prolong your work permit, but only if you give us the passport. He went and gave them the passport in September. End of September. They prolonged his work permit and his toleration until beginning of I think until April 23 actually. But all the while they had organized his deportation, and they took him into custody I think 3 weeks later, and tried to deport him. That failed because he didn't go willingly, and they didn't have visa for the police to accompany him to Ethiopia. And then he was kept in detention. And then we fought, and then this was the case that I told about. We fought about whether he's tolerated or not, because we knew he had all the, he spoke German, he had a job, he was self-sufficient. He had all the conditions, but they said, well, but he's not tolerated anymore. And this is a case where you can really see how the administrations, I mean, had they acted lawfully, they would have said in April 2022, now you qualify for the permit. Why don't you fulfill all the criteria and launch the application? He didn't know about it. He had no lawyer, and therefore he didn't launch the application, which would have saved him from deportation. And then we kind of went to the press and all that, and then they got such a shitstorm. Also, we pressured them with some constitutional lawsuits. So last week they released him, and now he's safe back in Germany. But it was a really, really close call. And you can really see how the administration here willfully kind of denied him his right. Another example, how they just kind of do what they want, is the second case here. That was a woman who was rejected, her also Nigeria in this case. Her case was rejected, and she arrived in 2015. And we got the case a few weeks back, and the social worker said, well, we are in communication with the administration whether she can get a work permit maybe, and maybe if she gets the work permit, then she can start an apprenticeship, or maybe a little training in order to qualify for the apprenticeship. And she was of the opinion that the administration was actually acting very nice, because they were thinking about giving her the work permit. Actually, after 4 years, there's no question that you get the work permit. They cannot deny it anymore. And she had been here more than 6 years. But because the applicant didn't know, there was no consultation. They can just play with these things, and they're not questioned anymore. And I found this is a really good example of how they just I don't know. You have the right on paper. It's a complicated way to find it in the legal text, but if you don't claim it, you won't get it. Also, she was anyway. Also, they should have consulted her and said you can also, because she has a child, and therefore 6 years is enough to secure your residence. She would have qualified for a permanent resident status. Obviously, they didn't tell that either. The third example that we have here is actually about this apprenticeship thing. He's also all the cases are in Bavaria, which is by bias me at the moment a bit because I'm working here in Bavaria for 3 months, and it's shocking what is going on. This third case, someone was tolerated also due to not having the passport, and they have this way of restricting your toleration in a way that you cannot get a work permit anymore if you don't work with them to get the passport. They did that with him. Now then he got an apprenticeship offer in Berlin. He's also restricted to it that he has to stay in Bavaria. And he started to cooperate to do everything what they wanted to get the passport. And according to the law, they have to lift the restrictions and they have to let him work and move to Berlin. But they just don't do it, and they say, well, you can't get the apprenticeship. It doesn't qualify because how will you go to Berlin to do the apprenticeship? But they would have to move first and say, well, they would have to lift the restriction. And we now probably have to go to court and fight them there. And the problem that illustrates is actually here you don't even know whether the courts will help you sometimes. But even if the courts will help you, you cannot do this in every single case. And if they do these minor things in every single, you cannot, because of every work permit that is not given, go to court, because you don't have the money for not even the capacity for the lawyers. We are overrun here. So that's a real problem with compliance by the authorities here with the law, because what should happen is that they comply with the law whether or not a lawyer forces them to do this. So that just to illustrate the problem of access to justice when you are tolerated. To maybe talk about something more positive, the current German government is really thinking, in parts at least, about lifting, enabling this, what they call Spurwechsel in German, which literal translation would be track change, so that you are on the humanitarian track and can move to the worker labor track. The thing is that's in the background there is that you have to know that, and I said this before, that Germany has a huge lack of especially skilled, but actually all laborers and workers, and they really have, it's very nonsensical to have a lot of people who want to work and you don't allow them to stay and work, and at the same time you try and get migration to Germany of people who are willing to work. So like the best thing that they could do, in my opinion, is that they get rid of this. There's one central legal provision that prohibits people to change tracks if they have a rejected asylum claim or take it back or so. If you would just got rid of that clause, then you would have the track change, and people could apply for whatever residence permit they wanted to, and that doesn't mean that it's easy either, because you would have to qualify for that residence permit. But right now, even if you are, I don't know, if you are a doctor from Nigeria and you have a rejected asylum claim, and there's a hospital that says, well, we would take him right away, you cannot even apply for it, even if you qualify for the residence permit. And that's very, that there are so many ways in which this has very nonsensical results. Often, sometimes it's also, if you just we had this case today, a Russian person who was kind of convinced by the administration to claim asylum, even though he's an engineer and he had a job offer by BMW here. And they convinced him to claim asylum, and now that's that. He's in the asylum procedure. He can only, if he takes it back, then he's on the wrong track. He's with the asylum procedure, he's on the wrong track. You can try and fight this claiming asylum, but it's very, very hard. It's often not possible. And he was kind of put on the wrong track, and now he's an engineer in Munich. There's an employer who wants him 2 days ago, before he claimed lodged the asylum application, he could have applied for the job. Doesn't work anymore. So that's, I mean, the best thing would be to just get rid of that clause. They're not going to do that. They're doing incremental change. They try, let me see what, here, they try, that's what I call track change light here. One example of this is actually what we talked about, the apprenticeship toleration. It's a way to change tracks, and I explained how this would work in practice like 2 minutes ago. So this is a way to that actually meets these needs. And then there is a reform that is planned for 2023. Basically, it should be in force in January, which is also kind of an attempt to alleviate, or basically to deal with people who have been here in the tolerated status for ages. The rules are, if you are tolerated, which is discussed right now and will be also decided on, if you are in the tolerated status for at least 5 years at the date of 1st of January 2022, so the beginning of this year, if you have no criminal record, and if you're currently tolerated, you get a 1-year residence permit. And during that residence permit, you can work on clarifying your identity, getting the passport, which is always something you need for the residence permits. You don't need it for this one, but it's kind of its probation period. And you don't also, one thing that you always also have to do for the residence permit is that you are economically self-sufficient. You don't have to be that for the Opportunity Residence Act, I call it now. But you get this 1 year to meet these criteria for another residence permit, and also to learn German in this case. So if within 1 year, which is very hard for many people, you get a job, you learn German, and you get your passport, then you can get into another residence permit, and then you can do this track change. This has been very quick, but who doesn't get the track change with that? People who arrived after 2017, because those don't have the 5 years full in the beginning of this year. Who doesn't get into it? If you have a criminal record, and we talked about this before, can be very minor offenses. I mean, it might go too much into detail in criminal law now, but what we talked about, if you get a illegal stay or illegal entry fine, that might already be, it might already be enough, so you cannot get this opportunity residence. Or if you, I don't know, if someone steals something in a supermarket once or so, that might also be enough. It's not like we are excluding heavy criminals here, but you're kind of excluding everyone who has been in touch with the law. And I mean, we all know that many people who have a criminal record don't deserve the criminal record often. This excludes some people, and people in the asylum procedure, which is also, I think, a bit nonsensical, because I mean, take the example of the Russian who was in the office 2 hours ago that I talked about. They might do an asylum procedure with him now. He doesn't want the asylum procedure. The authorities don't want it because they have work with it. He can't work now for the first 3 months at least. He will be relocated in Germany. It's a nonsensical procedure that is done now, just because you don't allow him to move out of the asylum system. So that is also something that is not solved with this. And at the same time, as in many European countries, you have to see that the asylum procedures are still overrun in Germany. You would need the capacity actually for other procedures. And the nonsensical thing is, at the same time, the German government really wants to facilitate skilled labor migration to Germany, but then they do this incremental change. The current example I wrote down here, I kind of took it already while talking. I mean, there's a lot of things I could still elaborate on, especially this whole visa thing that often we have a lot of, also in this case, Russian people who would like to, who are not in the asylum procedure, but who would like to work or get a permit, but they came with a tourist visa because that's the way to exit Russia right now if you are against the war. And then they say, well, you came with the wrong visa. Why don't you have to go back to Russia, apply for the right visa and return. But those people can't go back to, I mean, if you spoke out against the war, you can't go back to Russia and wait for 6 months and apply for the right visa. And then the authorities say, well, but that's what the asylum system is for if you're persecuted in Russia. And then you force people again into the asylum system, even though they would actually be on another track. So this whole idea of the, I mean, it illustrates a bit how stupid this whole track system is, and how we would have win-win situations that we make lose-lose situations of in many cases. I am actually done with what I wanted to say right now. I think it might be also a good time to open it up for questions. I can elaborate on anything. Yeah.
We already have one.
Oh, very long one. Okay. Okay. So yeah, the question is whether I could elaborate a bit about the difference of the tolerated status and the deportation ban. It's quite a big difference. The deportation ban is, I will perhaps go back to a slide in the beginning. The deportation ban is an actual, it's something that you get out of the asylum procedure. So if you go through the asylum procedure and they say, well, you're not a refugee, you're not entitled to subsidiary protection, but if we send you back to Afghanistan, that's one of the most common countries right now for deportation bans. If we send you back to Afghanistan, you would not be able to make a living that is kind of independent. You wouldn't meet your most basic needs. The economic situation is just so bad that it would be a violation of Article 3 ECHR or Article 4 of the European Convention of Human Rights. Therefore, you will get this, and this is a protection status. And then you take that protection status and you go into the national, into the system of residence permits and so on. And then you get an actual residence permit and you're here, you're secure. The toleration status, you don't get a protection status. You're rejected, your asylum application is completely rejected. And you go, there's just a factual reason that you cannot be deported, or a legal reason that is a legal reason that doesn't qualify for a protection status. For example, and this is also something in the asylum system, and I'm very sure that you have this in your countries as well. The protection status, you always look at the country that you come from. So someone cannot go back to Afghanistan because it's a dangerous place, because you can't make a living and so on. You talk about the conditions over there. If you have a child here and you cannot be deported because you cannot be separated from your child, that's a reason that doesn't depend on your home country. It's a reason that depends on on Germany, basically, because Germany has to enable you to stay with your child, and your child is in Germany. And that's a situation where, at the very least, you would have to be tolerated because there's a legal reason that's not connected to, let's say now, Afghanistan. But it's still a legal reason that bars the authorities from deporting you. it might also be a reason for you to get a residence permit on family reunification grounds, but that might be too far. So just to illustrate the difference a bit, toleration status means you can actually, you're subject to deportation. The national deportation ban is just that, you cannot be deported. And then there was a question in there about what the integration classes look like. They are classes. I mean, I have to say, I never saw one from inside, so it's more guesswork, I think. But there are classes where you learn about, I don't know, how does this and that work in Germany, some history, some yeah. I might be not the most qualified to say that, because I have to say I haven't seen an integration class from inside. I just know the tests that you have to take in the end, or that you have to take in order to kind of compensate for not having done an integration class. And those are tests that ask you about, I don't know, what is the technical term for the mayor in Berlin? And then you have to know that, or when was this and that moment in German history? And then you have to say that. So there are these kind of tests that try and show whether you kind of connected to the German society. How much time does it usually take in Germany to have a decision? Oops, no, the other one's gone. Sorry, to take a decision in the asylum procedure. Some months, years. It really, I mean, yeah. So the unpopular answer is it depends. And it depends a lot on the country that you come from. I'd say if you are Syrian, it might take months, maybe even just a month or so, or 6 weeks, or two months or so, just kind of from the top of my head. If you are, for example, if you come from Greece, let's take Afghanistan. Once it became clear that they couldn't send people back to Afghanistan after the Taliban took over, what the authorities did, so what the German Federal Office of Migration did, is that they just stopped deciding those cases. They said, well, the situation is so unclear. Actually, the situation wasn't unclear. We had a lot of reports. It just was clear that you couldn't send people back anymore. But they didn't, I mean, then they just stopped deciding. And they restarted deciding these cases, I think, a year later. So I mean, it's actually, again, a scandal. And I just saw that today, I saw that there's a proposition for legal reform, that they want to give them 21 months at the most to decide an asylum case, which is scandalous, I think. I mean, because it's almost 2 years. To say that also after 3, usually, so there's a rule in German administrative law that every administrative decision has to be taken after 3 months, barring individual circumstances. If you want to, I don't know, apply for permission for a nuclear power plant, that's obviously not going to be done in 3 months, and understandably so. With asylum procedures, this also applies. But then they say, well, we had COVID, we couldn't decide. Well, we have difficult factual situations in Afghanistan. We have to read through all the documents. We can't decide. And there's European legislation also that says 21 months is the very, very highest end of time, or the very longest that you can take. And then you can go directly to court and say, well, force them to decide, please. But just to give you an idea how the range can be, 3 to 21 months. And also, sorry, what you have to keep in mind is that if they reject you, the procedure isn't over. You have to go to court, and that might take 2 years. And I mean, I've seen cases where people were in procedures since 2013, which is when I didn't even know what asylum is yet. How long is the residence permit in general usually valid in Germany? it depends very much on the residence permit. You cannot, I mean, it really, it's different for every permit. It can be 1 year, it can be, to give you an example, if you get asylum status or like refugee protection, then it must be the same in your countries because it's European law again. It's 3 years. If you get if you get subsidiary protection, it's 1 year and it's renewed. Then the validity means only that it has to be renewed. Then it doesn't mean, I mean, and then they see whether the conditions still apply, and most of the time they do. So it's not taken away. Also, what's worth mentioning there is if you have 5 years full and the asylum procedure is included in that, then you can apply for permanent resident status, and that one is as it says permanent. It doesn't go away unless, and please tell everyone, unless you leave Germany for more than 6 months, then it's automatically gone. So never ever do that or come back in between. Do you know if any legal literacy trainings in Germany for non-lawyers, law students, to prepare people to be able to help translate administrative paperwork into easy language? I have to say I don't. Translation is a huge problem everywhere, also at the interviews with the asylum administration. Yeah, I can't help you there, I'm sorry. According to my research, in a few places, there is sometimes a policy of intimidation in Germany. Is there any truth to the situation? You would have to elaborate, I think, what you mean by intimidation. I can think of examples maybe, but it's very general. Maybe I go to the next question in the meantime. Is there a possibility to get a travel document even with a subsidiary protection? There is. Yeah, you have to apply for it. And I can't, from the top of my head, I can't say the preconditions, and it also depends on the country and your individual situation. But you can get a specific travel document, which is something. It's a problem that a lot of Syrians run into. Plus, no, that's the elaboration, I think. In other words, the extension of the processing time in order to give up their refugee stay application.
If Bahri want to speak, I can allow him to.
Yeah, please do, because
it will be better.
I think that maybe he's referring to like practices of deterrence or something like that in this sense, but let him articulate the question. If he can, because maybe
it's also
cannot speak because of, I don't know.
Yeah, technical issues.
I can. I mean,
devi sei tu l'organizzatore.
Or if he wants to like give us a sign, if for example, if I got the question, because I think you mean the deterrence practices, no, against migrants and asylum seekers,
and using kind of the long processing time in order to kind of deter them from pursuing their refugee application. I can only always, I mean, it's difficult, and especially in this, to kind of launch a general accusation for me, but I can think of one case definitely where someone just said, okay, if it takes that long, then I will try and go to Sweden, or then I will go back I don't know. So I think this was a person who came actually from Palestine, but had stayed in the meantime in Dubai, and she just went back to Dubai because she was like, okay, I'm not going to stay in a limbo for 2 years. There's something but this goes also way into detail, where there's actually something that we could call that you could call this extortion. Is that if you have a claim to family reunification, they reject it, and then you sue them. You have to sue in Berlin because it's against the foreign ministry and Ministry of Foreign Affairs, and then you have very good reasons that they would grant it, but you know that the lawsuit will take 2 years, and then they say, well, if we give you the visa, if you take back the lawsuit, and if you take back the lawsuit, that means that you have to pay for the court fees and for the lawyers' fees also. If you would win it, the other side would have to pay it. So they say either you can wait 2 years for your family to come, or you can have your family right away, but then you have to pay all the fees. That's what they call the I would call it extortion. It happens. It's common. What is the situation of our Iranian asylum seekers in Germany now with the current protests in Iran? The thing is, I cannot say, unclear. I think Iran has been a country where you would really have to prove individual asylum grounds, where it was hard to get like a national deportation ban or so based on general I don't know, conditions there or so. So either you had good claim to the refugee status actually, or you didn't, and that was what decided it. I can imagine, and I would try if I get Iranian cases, to kind of relitigate these cases now and say there's more of a general situation now where you have more reasons to claim asylum, but we don't have any decisions yet, so it's hard to say for sure. I can always only guess now. A person who holds an asylum document, asylum document in other member states, when claiming asylum in Germany, he or she will be discovered right away, or will have time to stay in the system for refugee camps. I think I know what you mean. If you have an asylum status in another member state, you are free to travel within Europe. And then you come to Germany and you have 3 months that you can be here legally. After those 3 months, actually 90 days, it's not 3 months. After those 90 days, you have to either try and claim protection, and then you will go into the asylum system. There are some ways, there's some tricks in Berlin that you can circumvent this. If you apply for resident status right away, you have to do that with a lawyer, definitely, because it's too difficult, and all this only works in Berlin. But you can stay 3 months or 90 days as a tourist, and after that you have to either go back or decide to launch an application.
Okay, I think we can take it as the last question, because
yes.
I mean
it will never be the last question.
Yeah, because I mean it's tiring to do this 2 hours lesson online.
Yeah.
So I don't want you to take advantage of your availability. I thank you again, Andreas. I mean, I think it was super interesting, and I also, I mean, I learned a lot, and I really wanted to know more about the system in Germany, and of course, there's a language barrier for many of us to learn more about the German legislation and the German migration policies. So I think it was super interesting, and I also saw like several connections with what we saw with in the cases of Italy and Spain. So I think there are lines that we drew somehow between the different lessons, and so thanks again.
Yeah,
see you soon.
Really interesting lecture.
Yeah, thank you so much. I enjoyed it a lot, and I also thought that the questions in the end pointed to people really kind of engaging with the topic. I'm very impressed by your whole program, and I wish I had known about it before. Then I would have been in the last 2 sessions, I think. But yeah, thank you so much for inviting me. And
of course, if you want to join the next classes, and I mean the next lessons, the round tables, more than happy. If you want, we'll send you the link, and also to step in and discuss with the other speakers would be super nice.
I can send to Andreas the whole program for the next classes. So if
that would be great.
Feel free to join and also give us a sign so that we can make you speaker and allow you to interact directly with the other speakers.
Yeah, it will be
thank you so
honor.
much.
Thank you.
Good. Then good luck, and see you soon.
See you soon.
Thank you so much.
Goodbye.
Have a good night to all people.
Ciao.